only 10 minutes, and then she will get rebuttal time. Okay?
Good morning. May it please the Court. Nancy Haas on behalf of the appellant husband, Eric Nadel. There are two issues before
Counsel,
the Court.
would you like to reserve some time for rebuttal?
Yes, I'm going to reserve approximately 3 minutes for rebuttal, Your Honor. Thank you. There are two issues before the Court that we have today. This was a dissolution of marriage case. The parties had one minor child who was born of the marriage. An amended final judgment was entered by the trial court, and in the amended final judgment, the trial court awarded the wife ultimate decision-making authority over education or academic decisions and over non-emergency health care-related decisions. Now, in this case, the wife filed a petition for dissolution of marriage. She never asked for ultimate decision-making authority. In fact, she specifically requested in her petition shared parental responsibility and a time-sharing schedule that would be agreed upon, actually, by the parties and filed with the court. Now, consistent with that, after the filing of the dissolution, the parties actually entered into a stipulation where they had equal time-sharing with their minor child. When the husband filed his answer and counterclaim or counterpetition, he asked for shared parental responsibility, and he wanted 50-50 time sharing with the parties' minor children, and he specifically wanted the court to adopt the parties' joint stipulation, which the court had indeed adopted by an order. Then we come to the trial. Now, prior to the trial, there's a very specific order in the family court that requires you to file a pretrial catalog. The husband filed his pretrial catalog. He requested shared parental responsibility, and we know Florida Statute Section 6113 is very specific as to what that is. There's also a
well, let me ask you this.
Yes.
Although it's not necessarily dependent, is Dad providing some support and medical expenses and please don't do that. Some support for these children.
Yes, actually, in the amended final judgment of dissolution of marriage, the trial court calculated child support that is being paid by the father. When I filed my reply brief, I specifically addressed the wife's arguments with regard to that, and Dad is absolutely providing support, and Dad is exercising his time sharing consistent with the schedule that was set forth in the amended final judgment, which is less than he wanted. He has the child every other weekend. He has the child every Wednesday overnight. He's a very active, involved father. But unfortunately, what ended up happening in this case, contrary to all of the applicable case law, which says if you don't ask for it, you don't get it, Mom was given ultimate responsibility or ultimate decision-making authority over education and medical. And here's the problem with that.
I'm sorry, go ahead. What's the problem with that?
The problem with that is it disenfranchises you from shared parental responsibility. If one parent in the back of their head knows that ultimately they can make the decision, it's a sham. In other words, Mom knows that she can make decisions ultimately if Dad doesn't disagree. So she says, well, this is where I want to send the child to school. And he says, no, I think this is a better school. And she says, well, too bad, I have ultimate decision-making authority. She had two chances here. She could have pled for it in her original petition.
Is this child in private school?
I don't believe so, and I don't believe it's part of the record.
Usually public school is where you live. Public school, where you go to public school is determined by where you live.
And
what's the big deal?
I don't want to conjecture. I believe at the time they were both living in a similar locale. It would not have been an issue as to the choice of school.
So it's really a fight about nothing.
Well, no, I don't think it's a fight about nothing. I think it's a fight because if Dad wanted to put the child in private school and had the financial wherewithal to do so, he couldn't do that. He would have to go back and file a supplemental petition and follow the law.
Or he could ask Mom and they could agree and it would all be over.
But Mom doesn't have to agree because contrary to the law, contrary to her petition, she had ultimate decision-making.
Is this a medically needy child? Is there anything wrong with this child? That there's some, surgical questions and, psychological questions with this child where there's some real problem about getting medical care that really is an issue that's...
Okay, the record was silent as to that, but the law is very clear. Dad has an equal right to participate in those decisions. He has an equal right to attend the doctor's appointments. He has an equal right to decide upon any kind of health care by giving a parent ultimate decision-making authority when it wasn't requested. And Mom didn't follow the law. She didn't file a pretrial. Dad was not on notice. This court was very clear in Cruz versus Dominic that while the case law permits ultimate decision-making authority to be awarded to one parent, the allegations in the parties' pleadings must put the other parent on notice that that's going to be requested. That didn't happen.
Was the wife represented by counsel at the trial?
The wife was not represented by counsel at the trial.
And I think the financial affidavits of the parties were filed. I recall looking at those. So wife was unrepresented and husband was represented.
And there were several financial affidavits. Actually, Dad filed a few and Mom filed a few as well. So with regard to ultimate decision-making authority, we had a recent case that came out just by the time I filed my reply brief in this case, Fizarro, which is from the 2nd District, I believe, and it's from March of 2013, and it's exactly on point. That was a case where the trial court gave Mom ultimate decision-making authority over education or academic decisions and over non-emergency medical care. And the 2nd District said the court made no oral or written findings on the factors governing shared parental responsibility to justify that award. And similarly, in this case, the court made no findings that there was any animosity between the parties, that the parties couldn't share parental responsibility, and they couldn't make those decisions jointly.
And you're arguing this is the equivalent of giving the mother ultimate responsibility or ultimate authority to make those decisions.
That's correct.
Help me out, Ms. Haas. If the parents don't agree, how does the disagreement get resolved under our system?
The mechanism under
Let's say the parents don't agree where the child's going to go to school. Obviously, the kid's got to go to school. So what happens?
And under the statute, it provides for you to go back to the court and for the trial court to take that into consideration. At that point, if the parties don't agree, then the law is clear that the court can award one party ultimate decision-making authority. But you have no pretext for that in this case. The record doesn't establish that there was any inability by the parties to share parental responsibility or any hostility. And what's more important...
Although it does appear that there was some chicane, no, I wouldn't say chicanery. The husband in this case lives in, at least his financial affidavit shows, he lives in a very nice home, a very pricey home, and at one point drove a very pricey automobile. Yet and at one time made a fairly decent amount of money. But all of a sudden it seems that he was very needy. So it looks as though, just from reading, because one side is making a record and the other is pro se and is adept at making a record, that the trial judge, who has the discretion to hear, was looking at the people and saying, I see something here that equitably I think is not quite right. The father is not being totally up and up with me. And why isn't, what is the abuse of discretion here? We have to say that no other reasonable person in the whole universe would come to this conclusion.
Okay, well, I'm going to cover both issues with that. First of all, when the trial court entered the parenting plan, it was a form, and it's a form where you check off boxes, and boxes were just checked off. It was handwritten. However, subsequent to that, when the amended final judgment was entered in paragraph 5, the trial court very specifically put language in about shared parental responsibility and specifically said, so whatever the record had been, by the time that final judgment was entered, the trial court said that in this case, the party shall share parental responsibility. Said decisions include education, discipline, religion, medical. And the last sentence says the party shall abide by this definition of shared parental responsibility. Very specific that there was to be shared parental responsibility. So whatever the record had been before, what was heard at trial and what was put in that amended final judgment, there is clearly a contradiction. That parenting plan was incorrect. The language in the amended final judgment was clear. The court wanted there to be shared parental responsibility, and by checking that box for ultimate decision-making authority when it was neither pled for and nor requested in the pretrial catalog and set forth as it was supposed to be is error. And that's an abuse of discretion, and the case law is very clear. Now, with regard to the financial issue, the trial court clearly erred in ordering the husband to pay to the wife $129,000. These were loans that were made by the wife during the course of the party's marriage. The husband had a business. He had a bench ad business. When you drive on the road, you see the ads on the bus benches, and that was his business. That business supported the family during the party's intact marriage. The wife, in her petition, never pled for an unequal distribution, never pled for special equity. She actually said there are no assets and marital liabilities. There's nothing to be distributed. And in addition, she said there's no other relief that I'm requesting.
But it looks as though most of these transfers took place after the, unless I'm reading the dates wrong. No, they were all before the divorce. It was after the child was born.
Yes, and the transactions are actually withdrawal slips. Two of the transaction slips, which were entered into as exhibits at the trial, actually look like they were notated after the fact. The writing is not consistent. These all said loan to corporation, loan to Benchad, loan to corporation. I mean, the case law is abundant with regard to this matter. I mean, we have the case of Ray versus Ray from the First District Court of Appeal, and we have the case of Ray, R-E-Y, rather than R-A-Y.
So you're saying, she says those were that money was inherited. It was a loan to a corporation. It wasn't a gift to her husband.
Yes, and the law is very clear. If it was a loan to a corporation, then she needed to join the corporation in the party's dissolution of marriage proceeding. The husband has no personal liability for that loan, so she had to go.
If it was a loan to the husband, which it wasn't, but if it were, it couldn't be recoverable.
Correct. And the law is very clear. I mean, this
is a family obligation and family discharge of said obligation.
Absolutely. And this court in Olson versus Olson adopted the reasoning in Ray and said there's a marked distinction between a circumstance where a special equity is being sought in a tangible asset because the contribution to the acquisition of that asset was an above and beyond the ordinary marital duties, and the circumstances where one partner is permitted to receive a judgment against another marital partner for loans made during the marital relationship. The latter situation is totally incompatible to the unity concept of marriage. I mean, that says it all. And so does Florida Statute Section 61075. It clearly says if the court did not distinguish this as a non-marital liability or set forth an unequal distribution, then at the very least, it was a marital liability subject to equitable distribution. And furthermore, the law is also very clear that the corporate veil cannot be pierced.
The trouble is, if you loan something to your spouse, it's a liability of you, but an asset of the spouse. So it doesn't make any sense.
No, it's a marital asset and a marital liability.
Well,
both,
the court could have
correct.
Divided it up by saying, we're going to give the value of this asset to you in the distribution because you're still living in your $700,000 condo, and you can have that, and the lady will get her corporate interest back.
But you know what? The trial judge didn't do that. The trial judge actually stated in the amended final judgment there are no marital assets and no liabilities. This trial judge was astute. If she had felt that there was $1 million home that was being distributed, she would have set that forth. She specifically said there are no marital assets and no marital liabilities, but somehow found these loans, which were clearly either a marital liability to be equitably distributed, or the husband should not have been responsible at all. The corporation should have been joined. He was not personally liable for these loans. So the trial court erred in awarding the wife ultimate decision-making authority with respect to education and non-emergency health decisions, as well as in ordering the husband to pay this liability, which was clearly a marital liability or a liability solely of the corporation, which was never joined to the action. So the amended final judgment should be reversed, and these matters should be remanded. Thank
Counsel,
you.
we let you go over, but we'll give you 1 minute for rebuttal. We'll hear from you now.
As far as I did represent myself, and I do, as far as everything that went on since 2009, I did file at our divorce a pretrial catalog myself. As far as we did not live in Aventura at the time. The second that we weren't together, I was living in my mother's house in Pinecrest. Since 2009, a lot has happened. Just bear with me. I'm sorry. I represent myself. So since 2009, after supervised visitation for the father, we were in front of Mindy, Glazer, and the child not only was in pre-K, which I myself got her into a program, and there were problems when she was in the school with him bringing her back and forth. As far as after that, the schooling, I did ask at my divorce hearing to have the child in the school in my district. I asked on different occasions due to the fact that we couldn't agree whether I sent her to Baptist Hospital on an occasion or the doctors that I chose. The child, I have Medicaid through the state for our daughter. She's 6, and the father has health insurance for himself. I do not have health insurance for myself. Part of responsibility, I thought, is medical. As far as decision making, I have numerous emails for the court that not only do I discuss with him, would you like to do the dentist? He's never taken her to a dentist. He says, you do it, I'm busy with work. I do the doctors, the dentist. I have consulted with him about this. From day one, from pre-K, from the homework to every single day of homework, even if it's his week, he's never opened up a day of homework. I have full responsibility of our daughter. He was ordered to pay $92.16 plus the rearages. Since May,
A week?
$92 a month, $92.16. He got, I filed a motion for increase of child support, which is on June 18th. The $92.16 plus give or take $50 of rearages has not been in here since May. Like I said, I think he would like ultimate decision making without responsibility. I think it'd be wonderful. I've never said, you know what, don't take her to a doctor. He had her for 4 days not that long ago, and I have an email, he didn't take her to a doctor. That's his timeshare. That's responsibility. He sent me an email, you take her back. She was so sick that I took her that Monday to the doctor, and she was home in bed for 3 days. Full responsibility. I'm happy to do all of this. I'm her mother. But 2 people should have responsibility. You know, from before I had health insurance, Medicaid through the state, I have everything from walk-in clinics from his timeshare and mine, okay, that I had to go and take her to with the help of my family, okay? I'm the one who was responsible for the pre-K getting her in that. We did have, which I brought to the court, I had issues with because she was on a program for pre-K, that because she was tardy, there were problems. You know, I've never had the child tardy to school. You know, he has her and wants her more timeshare, but just in the last month she was late to school twice.
Ms.
You know,
Fishbein,
for kindergarten.
If I might just interrupt you, remember, we're in appellate court, so of course we're not hearing testimony. We're only reviewing what happened below. So I have a question for you, if you don't mind.
Sure.
I'm changing the subject a little bit.
Okay.
One of the issues has to do with your loan to your husband.
Right.
So could you tell us a little bit about the testimony at the trial?
Right.
Don't tell us about what happened
Okay.
after the trial.
Okay.
Testimony at the trial regarding your loan to your husband.
Right. My loan to my husband was, this was my inheritance from my grandfather, everything that I had to my name. My husband came to me and said, I need you to loan me money, you know, and through a rough
Was this the
edge-
testimony at trial
Yes.
you're telling me? Okay.
This happened in trial. What I said is what happened. I personally loaned my husband my inheritance. Yes, to the corporations. That's what he said he needed the money for. I personally loaned my inheritance to him, trusting my husband. He said, not only will you get this money back, but I will give you interest. He was my husband. I trusted that I would get the only money left to my name back with him knowing that that was my inheritance. I was out of there with nothing. So with that in mind, yes, I did trust that I would get the money back. So I did loan him my inheritance to use at his discretion, which he chose to use for that. You know?
Thank you.
Thank you very much. Let's hear 1 more minute from the appellant.
Thank you, Your Honor. The wife's response with regard to the loans is completely akin to the fact pattern in Ray versus Ray from the First District Court of Appeal, where the wife received an inheritance during the course of the marriage. The husband was operating a farm with his family. The farm supported that family. The bench ad company supported their family during their intact marriage. And the appellate court very clearly said that that supported the family. They're not recoverable as loans, and it was improper. So, and in fact, the wife in her answer brief specifically made a statement with regard to the loans, and I believe she said, just because he used the money for his business doesn't change the fact that it was a personal loan to my husband to use at his discretion. But unfortunately, that argument completely fails. It's against the authority of Olson, Ray, and Ray. And again, I would just reiterate that the trial court erred in this matter. You're entitled to due process. And if there are no pleadings enunciating what relief the other side is seeking, then it's error for the trial court to award that relief. And the law is very clear on these points. So again, we would request that the amended final judgment be reversed with regard to those matters. Thank you.
Thank you both. We are adjourned.